Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Welcome back to another edition of TFE Talks. I'm again your host, David Thompson, today, and we're going to let Jordan keep it going and do another podcast where he can show us his knowledge. For those that don't know, Jordan is a shareholder at Thomas Fisher and Edwards and is also a certified specialist in estate planning and probate law here in South Carolina, and we look forward to having him on today.
Yeah, thanks for having me, David. And today's topic, we're talking about life insurance, and you're showing that we have some insurance on the hosting side of the podcast, just in case anything were to happen to me.
I we want to make sure that we are properly insured against all risks, and now that I can sit in the host chair from time to time, we should be covered on that front. But like you mentioned, today we're going to talk about irrevocable life insurance trusts. And before we even get into what is an irrevocable life insurance trust and how do they function, I want to start with what I think is a threshold question. Is our life insurance proceeds taxable?
You know, that's kind of funny, David, because we send out an estate planning questionnaire to our clients, and it asks them about all of their various assets. And sometimes I'll have a client that doesn't include their insurance assets on there, and they say, oh, you don't really need to know that because life insurance isn't taxable, because they've heard that. And you know, my answer is usually something like, well, I'll be the judge of that, because life insurance typically is not income taxable. It can be income taxable in certain rare circumstances, but it's typically not income taxable. But life insurance, if just held by a person personally in their personal name, is included in their estate for estate tax purposes. And so it very much can be estate taxable. And unless you take further steps, such as setting up a life insurance trust like what we're going to talk about today, it is something that is going to be estate taxable to the extent that someone otherwise has a taxable estate.
Right. Yeah. So I think I think that's a great way to summarize it, because I feel like one of the core benefits that clients believe about life insurance is that it's not taxable to the recipient. And as you said, that's generally true from an income tax perspective. However, a lot of times clients aren't aware of some of the other ways that the insurance could be taxed and what that may look like for them. So what are some of the, I guess, strings or things that cause life insurance to be taxable from an estate tax perspective?
Yeah, so from an estate tax perspective, what we're looking for, the magic words are what we call incidents of ownership. So the most obvious of those would be actual ownership. If you own life insurance on your own life or on someone else's life, then that is an asset that you own. It's included in your estate for estate tax purposes. But there can also be other less known incidents of ownership, which are essentially just levels of control that you may have over a certain life insurance policy. And typically, if you can exercise control, especially if you can control who the beneficiaries of that policy are going to be, then you likely have incidents of ownership over that policy, and it may be included in your estate for estate tax purposes.
I guess, so how does ownership in, and I'll use the term ILIT, irrevocable life insurance trust, ILIT, how does ownership in an ILIT differ from individual ownership?
Yeah, so the idea with ownership in an ILIT is if I am a wealthy person who needs to have a lot of life insurance to perhaps fund an estate tax or to replace my income, then I may decide to, rather than owning a policy personally, to instead have the policy owned by a trustee of a special type of trust that we call an irrevocable life insurance trust. And so that means it's irrevocable. I can't change the terms of that trust after it's been set up. And it's a life insurance trust in that it is designed to hold life insurance or a life insurance policy. And so I designed that trust so that the trustee is going to hold the policy for the benefit of my beneficiaries, whomever they may be. And I am simply the person who created the policy initially or began funding the policy by making premium payments to the trustee for them to ultimately make those payments on the policy.
So then the next question I get from my clients is, so what happens to the insurance benefits? We put it in a trust, and we'll talk a little more specifically about that, but what happens to the insurance proceeds when I pass away, when the insured dies? Does that impact how they may receive these assets?
Yeah, and so it can be very flexible in that respect. The insurance trust is typically going to be designed so that the liquidity is created upon a person's death for some specific person. Maybe they need, for some specific purpose, maybe they need liquidity to help operate a closely held business that they have. Maybe they need liquidity to pay an estate tax. But the idea is that when the principal dies, when the individual dies and they have this insurance in an insurance trust, the policy is going to pay out to the trustee of that trust because the trust itself will be the direct beneficiary of the policy. But then the assets will typically be held in trust for the benefit of one or more beneficiaries who may be spouses or descendants of the policy or the insured rather. And so in that scenario, it's going to be for the family's benefit, but there's also that expectation that the funds may be needed to fund liquidity as part of the estate tax process.
Right. So exactly. I think that's a great way to think about it, is that we're kind of moving the receipt of those proceeds kind of off your personal balance sheet and moving them into the trust balance sheet. And whatever the terms of the trust provide is really how those assets will be disposed of. And there's really a whole retinue of choices or options that you could pick from.
And just to kind of give a classic example, so like current estate tax exemptions are $15 million. So if I was meeting with a client who was worth $20 million, well, if they were to die the next day, they'd be $5 million over the exemption. They would pay a 40% tax, so they're going to owe $2 million of estate tax. So they may be tempted to help pay that tax by buying a $2 million insurance policy. But if they do that in their personal name, they've taken the value of their estate from $20 million up to $22 million. Mm-hmm. That creates $800,000 additional estate tax liability.
And so, reduces the liquidity that's available to pay the tax.
Exactly. And so the idea would be if they instead get that extra $2 million in a separate irrevocable life insurance trust that's designed to be outside of their estate, then the $2 million is there to pay the estate tax that's caused by the other $20 million, but it then allows the other assets that are owned by that individual, oftentimes which is a closely held business or something else that is illiquid, to be used for other purposes and for the benefit of the family.
Right. I think the key to think about is that having those funds in that ILIT can provide for immediate liquidity so that, you can have a timely, but not rapid administration or sale of certain assets to generate liquidity at the estate level as may be necessary.
Right.
So let's talk about like a basic structure of an ILIT and like, what does that look like? What does the client have to select? Can I identify all the parties, and let's go from there?
Yeah, so they typically have to start by picking a trustee who is going to be someone other than themselves. As long as it is a policy that is not also on their wife, like if it's a second to die policy, then they cannot have their spouse be a trustee of the trust either. But if it's a policy just on the individual's life, then he or she could have his or her spouse be the trustee of that trust, or perhaps one of the children, assuming that the trust is designed in proper ways, or just some independent third party, or even a bank or a trust company. Now, I do think that there can be a lot of value here, even more so than with respect to other trusts, for having a bank or a trust company serve as a trustee of an ILIT, just because there is quite a bit of kind of annual maintenance that goes on with these, because you need someone to receive contributions, make premium payments, send certain notices that we'll talk about in a moment to beneficiaries, and then ultimately, upon death, receive those proceeds from the life insurance policy. And so I do think that this is something where it can be helpful to have an institution serve as trustee, but it can, as long as this trust is designed properly, it can also be a related party. So that is the kind of the first step, is picking that trustee. The next step is actually acquiring a life insurance policy. And so that's going to require meeting with your insurance advisors, making sure you qualify for life insurance from a health standpoint and an age standpoint, and then, getting the best policy with the best premiums that you can possibly have, deciding whether or not it's going to be a term policy or a whole life policy. We often see whole life policies with life insurance trusts because we want to make sure that that payout is there. But it could potentially be a term policy in some cases as well if we're just trying to kind of bridge a certain period of years that we think that it will be needed.
Yeah, no, and I think like a classic example of where a term policy in an ILIT can make sense depending on what the client's, risk tolerance is or level of planning that they're looking for is, a professional. If you're an individual that's a highly paid professional and have acquired your own assets, well, let's say you're a surgeon and you have 10, 12 million of your own assets and you also have that $5 million term policy that's going to cover a period. Well, on paper, your your assets, you're not taxable, but with that life insurance, well, you've created an estate taxability problem in the event of your death. So I think sometimes, kind of balancing what the insurance is there for, who the client is, why they need it, can help inform the term versus whole life or a permanent insurance policy of some other structure. So let's go back to, and I'll start with a more broad question and we'll narrow down to the notices that you kind of mentioned. You've mentioned that the trust will own the policy. Trustee will own the policy and the beneficiary of the policy will be the trust. How do we make premium payments if we've got an annual premium or some other, premium that has to be paid from time to time? How does the insured continue to make sure that those are paid?
Yeah, and so I'll start by noting that an ILIT is essentially built on the chassis of what we call a Crummey trust. Mm-hmm. And we use Crummey trust for all sorts of reasons, but I think ILITs are one of the primary uses of Crummey trust. And you hear that word Crummey trust, it sounds terrible, but it's simply named based on a court case that essentially approved this type of planning. So it's Crummey, and it's just the name of the family that was involved in that. But the idea with the Crummey trust is that it's designed so that when someone makes contributions to it, those contributions are withdrawable by a beneficiary for a short period of time. And by making those contributions in a way that they're withdrawable for a short period of time by the beneficiary, that qualifies that contribution as a gift of a present interest rather than a gift of a future interest. Because in general, if I make contributions to a trust for someone's benefit, I'm only benefiting them at some undetermined period in the future, whereas if I make contributions in a manner in which they could theoretically withdraw it immediately, then it's treated as though it's a present interest. That is important because the gift tax annual exclusion, which is currently $19,000 per year, only applies to gifts of present interest. It does not apply to gifts of future interest. And so by designing the trust as a Crummey trust, we make it so that the grantor makes contributions to the trust, they're treated as contributions of a present interest, and therefore they qualify for the gift tax annual exclusion. So if you had a scenario where the premium payments on this whole life insurance policy are going to be $40,000, but if you can design the trust so that it is for your spouse and your two children, and we can gift up to $19,000 to each of them each year without using any gift and estate tax exemption, then that makes it so that $57,000 could be contributed to the trust each year without using gift and estate tax exemption. It qualifies as annual gifts. And so that is the idea, is that then we can get that amount into the trust each year for purposes of making the premium payments, and we're not using up any of the gift and estate tax exemption of that individual. So it's a very efficient use of these contributions.
Yeah, no, I think that's a great way to think about it. So let's talk about what maintenance requirements come from that, right? And you talked about the administration of ILITs. What do we have to do, or what is the best practice when making a contribution to an ILIT and documenting that contribution?
Yeah, and so it goes back to that Crummey case that I referred to, and some of these facts were in that case. But the idea is that we want to feel as though those beneficiaries truly have an ability to withdraw those contributions. We don't want them to actually do it, because if they do, then there's nothing there to pay the premiums. So hopefully they understand that they should let the money sit in the trust so that it can be used to fund the life insurance premiums. But we do want them to have that ability, which means, one, they have to know that the contribution was made. So we send what is known as Crummey notices. We have the trustee send a notice to the beneficiary that says, hey, the grantor has contributed this amount to the trust. You have X number of days to withdraw it. We typically want to give them at least around 30 days to withdraw it. I think I've seen as few as 15 could work, but 30 is typically what is thought of as being the safe period in which they can have that ability to withdraw. We want that 30-day period to actually pass. We want to wait the 30 days before the premium payment is made because we want that Crummey power that they have to lapse, and we don't want them to release it in an affirmative way. We want them to just sit back and let the Crummey power lapse over that 30-day period. And then once it has lapsed, we then want the trustee to be able to take those amounts and use it to pay the premiums on the life insurance policy. Right. So it's just important that we give that ability for the funds to be withdrawn. And also there cannot be any prearranged agreement that the Crummey beneficiary is not going to withdraw the funds. Right. Hopefully they understand the planning and they understand why it's valuable to have the funds in there to pay the life insurance proceeds to ultimately provide estate tax liquidity. But it can't be something where we say you are, under the table, you're not allowed to withdraw these funds. Though we do at least typically design ours so that if anyone ever did withdraw funds, we have an ability to exclude them in the future from future contributions.
Right. No, I think that's an important point. And I was going to make that is that the way that we would design, and I think thoughtful practitioners would design an ILIT, is that in the event a specific beneficiary maybe exercised a withdrawal power in a way that was, disadvantageous for the beneficiaries in the trust and the insurance, well, our trust allows future contributions to be detailed or restricted by the Crummey letter that's used to notify the beneficiaries, which I think is a very important feature and is really a critical tool for just flexibility in terms of administering these trusts. One last item I want to bring up, or I guess I have two last items. Can you briefly talk about and again, we've talked at length about making these gifts a present interest for gift tax purposes. Mm-hmm. Let's talk about generation skipping tax, because I know that, again, it's a little beyond the field here of where we're looking to cover, but I want to just make sure that people understand, is there a difference in the gift tax effect and the generation skipping transfer tax effect of these contributions?
Yeah, there is, and I think this is something that gets missed a lot because just in the way that, people assume that life insurance is always not taxable for any reasons, and we talked about why that's not necessarily true. There's also this idea that if you make contributions to a Crummey trust that you're not using any exemption. Well, you're not using any estate and gift tax exemption, but you could be using generation skipping transfer tax exemption, depending on how the trust is designed. But if the ILIT is designed in a way that it's going to remain in trust for multiple generations in sort of a dynastic format, which oftentimes we do design it that way, then it is likely that the trust is going to automatically allocate generation skipping transfer tax exemption to its contributions. And while the contributions under the $19,000 per donee are not using up any gift and estate tax exemption because they're qualifying for that annual exclusion, they typically are not qualifying for an annual exclusion for generation skipping transfer tax purposes. The way in which you qualify for that annual exclusion is very narrow. It typically requires that there's only going to be one beneficiary and that the assets are going to be included in their estate. And so typically for an ILIT where it's for the benefit of spouse and children, and then it's ultimately going to go on for grandchildren, those contributions are using up some generation skipping transfer tax exemption each year. And so that requires some thought about, one, do we file a gift tax return even though there was not a taxable gift this year? Do we still file a gift tax return to report the use of generation skipping transfer tax exemption so that we can track that? It also requires consideration of, in trust design to begin with, do we design this to be generation skipping? If it's a term policy, we may not want it to be generation skipping because we could be using up generation skipping transfer tax exemption, and then the person could die after the term has expired and there could be no insurance, so we would have wasted GST exemption. And so if it's whole life, then it's probably worth allocating that GST, but you just want to be sure that you know where you're allocating GST, how you're using it, and thinking through that with respect to the trust design and then the reporting on the gift tax return side.
I think all of that is a great summary, and I think that is actually kind of one of the most pivotal, things that needs to go into the design of the ILIT, and I think it is something that's often overlooked or underappreciated by practitioners or understood by clients. But spending that time to get that right, and especially with a client that is either taxable or potentially taxable, in our mind, it's probably almost always the correct solution to file that gift tax return so that we can make sure, one, we're trying to run statute on the gift, even if it's subject to the annual exclusion, and two, make sure that we have a good number for their generation skipping transfer tax exemption, because if they make 10 years of contributions, that's going to impact that number depending on the design of the trust, and we want to make sure we understand that. So the last thing I'll leave you with is, and this comes up quite a bit, is let's say a client comes to you for estate planning, and they are potentially taxable or taxable. They're on the line or close, and they've got a $3 million permanent insurance policy in addition to being otherwise taxable. Does it ever make sense for a client to set up an ILIT with an existing policy? In other words, we don't set the ILIT up with the idea that it's going to acquire the policy, but that we're going to use an ILIT to hold something that the client already owns. And if so, how do we go about doing that?
Yeah, so it would be possible in that scenario to just gift that existing policy to a new ILIT that we set up, but that is going to use up some exemption when they make that gift to the new ILIT based on whatever the value of that policy is, and that's something that typically we use the interpolated terminal reserve value of the policy, which is something you have to go to the insurance company and request. But a downside of just making that gift is that there's a 3-year look-back period where for 3 years after that gift, the policy proceeds are still includable in that person's estate for estate tax purposes. There's a 3-year look-back. So to get around that 3-year look-back, in my opinion, the better way to get that existing policy into an ILIT is to sell the policy for fair market value. So the way that looks is you're still making a gift, but we gift other assets to the ILIT that are worth approximately the amount of the interpolated terminal reserve value. And then we turn around and we sell the policy to the ILIT in exchange for those other assets. And with that being a sale for full fair market value, that makes it so that we avoid that 3-year look-back period so that we are now immediately getting those insurance proceeds out of the grantor's estate in that scenario. One other thing I'll note is that this can also happen in a way when like people just kind of put the cart ahead of the horse on planning, because they can think, oh, I'm going to get an ILIT, so let me go ahead and meet with my insurance advisor and get this insurance policy. Well, now the moment that they've got that insurance policy, now we're looking at either gifting or selling it to the ILIT, versus if they will instead plan together with the insurance advisor and the attorney so that the ILIT can be set up and the ILIT itself, the trustee of the ILIT, can go out and acquire that policy from the forefront. It makes it so that we're not looking at avoiding that 3-year rule, because the policy can be owned by the trust from the very beginning. But certainly with respect to existing policies, I think those sales to avoid the 3-year rule are well worth it. You use up the same amount of exemption either way. There's maybe a little more legal complication with the preparation of documents, but you're avoiding that 3-year rule, and you certainly don't want to go through all this rigmarole and all of this acquisition of insurance just to have it included in your estate because you happen to die 2 years and 6 months later, when you could have easily avoided that 3-year look back just by taking a little bit of extra legal step on the sale rather than the gratuitous transfer to the trust.
Yeah, and one of the point on selling them is, theoretically too, maybe you don't potentially have to use exemption at all. We could make a contribution and potentially maybe sell it back to the grantor, or sell the policy from the grantor to the ILIT in exchange for a note. Now, again, that creates and when I say note, a promissory note, right? An enforceable debt arrangement, right, between the insured and the trust. Now, that creates other complexities and things that have to be monitored, right? Because ultimately the note will have to be paid back, and we want to do that. But maybe it's potentially possible that we can, still utilize those annual exclusions and maybe not burn up exemption, depending on exactly how aggressive or potentially taxable the grantor necessarily is. But I think, are there any other comments or any other practical tips that you leave for listeners in connection with ILITs, Jordan?
I think just the other practical tip that I would just give is, I think that, ILITs used to be really popular when we had an estate tax exemption of $1 million, because a lot of people were paying estate tax then. And so it was very helpful at pretty much all times to have that liquidity to help pay the estate tax. But I think that ILITs are still very useful. Just from the standpoint of not as many people pay estate tax, but there are a lot of people that are maybe on the cusp of they potentially could, but they don't have so much in assets that they're willing to give big chunks away to engage in other complex estate tax maneuvers that we've discussed on this podcast. And so an ILIT can be a nice way to, with flexibility, plan for like that outside chance that you may owe an estate tax, but also if you end up not owing an estate tax, it's just a nice liquid asset that's there for your family at the end of the day and is there for their benefit. So I wish that these would be considered by clients a little more than they are, just from the standpoint of, I think people still value insurance. All of my clients I meet with, they still come in with insurance. So I think taking that step to design the insurance in a way that it is outside of their estate, just on the off chance that they end up owing an estate tax because their estate could go up in value, the exemptions could potentially come down at some point in the future with future law changes. And so I think it's just a nice flexible way of planning, and it's always best when you start early with those type things and start making the contributions versus waiting until you know that you're paying an estate tax and then having to scramble to find out how you're going to pay it.
No, I think that's a great point, and I appreciate your insight, and I think the listeners do as well on this question of ILITs and their use and functionality and how we can better use them and be aware of some of the issues that clients face with them. But that brings us to the close of another edition of TFE Talks. We thank you for listening and look forward to speaking with you soon.
Thanks.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.